Welcome back, everybody. I'm reminded as we kick off this panel, a very old movie with Tom Cruise called Jerry Maguire, and there's this scene where they're like, "Show me the money!" and they're jumping up and down. So this won't be nearly that exciting, but it's on the same theme because this is our costs and financing panel, and we have three esteemed colleagues joining us. First of all, Aaron Fuse-Brown will be speaking on federalism, private law, and medical debt, the role of state private law in consumer protections against medical debt. This is an area of interesting activity in recent years, a lot going on. So I'll turn it over to you, Aaron.
Great, thank you very much. Thanks to Glenn, Wendy, and Chris for this great conference, and to the Petrie-Flom staff. This has been a fabulous day so far. And yes, Chris and I have worked on tracking some of the state developments in the area of medical debt protection, consumer protection, so it's something that it is an exciting area of development. So the question is really a regulatory design question in this paper, which is whether or not the problem of medical debt is best addressed through, actually I think I have slides.
I don't think I got your slides, Karen.
Oh, okay, it's all right, I don't really need them. Whether the question of medical debt, the problem of medical debt is best addressed at the federal or the state level. And of course the answer is both. And the reason it's both, and whether or not it's better addressed through private or public law, and again, the answer is both. It's both and. And that is because medical debt is best addressed through combining federal and state, public and private law approaches, because it sort of is a pervasive problem that has both macro effects as well as, of course, individual extreme burdens. And so some combination of state and federal, public and private is necessary to fill all the gaps. No one system of legal protection or consumer protection can provide meaningful protection against medical debt. So the problem of medical debt is enormous. I'm not going to go over the descriptive elements of the paper. You can see it in the paper itself. You know, one estimate by Kaiser Family Foundation, 100 million people, 41% of adults carry medical debt. It's also the most common type of debt reported on credit reports. So it is sort of a pervasive problem. It's a huge problem. Even if the individual size of the debt isn't that big, it has an impact on the financial and health well-being of the people who carry the debt. And of course, the burden of medical debt is inequitably distributed. Like everything else in healthcare, you know, there are racial disparities, there are regional disparities, there are income disparities, where the structural racism that's sort of shot through the system shows up in sort of the burden of medical debt. You know, for the biggest example being the Medicaid non-expansion states, which also happen to be Republican-led, a lot of them sort of former Jim Crow southern states, including my own. They, you know, have this, the lack of Medicaid expansion has a disproportionate effect of the amount of medical debt carried by the population, which then of course is distributed unequally, carried more by Black and Latino families and communities than non. So when we think about sort of the federal policy backdrop, there's some significant efforts that have been made. 2010 really marked the turning point for federal policy on medical debt, both with the passage of the Dodd-Frank Act, which created the Consumer Financial Protection Bureau, and of course the ACA, which implemented rules for billing, collection, and financial assistance for federally tax-exempt hospitals. So, you know, Dodd-Frank and the CFPB authorized the CFPB to regulate credit reporting and the collection of debts, medical debts, under the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. And yet, that was, 13 years ago, despite its regulatory authority, CFPB's main efforts to date have been to study the issue, which has not been without, you know, any effect at all, but it's mostly been to put sort of information out there and to use sort of its bully pulpit to secure voluntary commitments by credit reporting agencies to treat medical debt, to weight it less in your FICO scores, and to treat medical debt a little bit with more care than it was before, but it doesn't eradicate the medical debt from showing up on those credit reports. And it has regulatory authority, but has not chosen to pull that lever up until now. I think this group is familiar with the IRS rules, so I'm not going to belabor them here. I'll just point out that the ACA's most important policy on medical debt turns out, again, not to be the 501R tax rules for tax-exempt hospitals, even though those on paper look like they most squarely address the issue, but in fact was the Medicaid expansion. If you actually look at what had the most impact on the burden of medical debt carried by the population, it is the Medicaid expansion and not the IRS rules, primarily because the IRS rules are under-enforced, they're underpowered, they leave a lot of discretion to the hospitals, and they've basically never been enforced against a hospital in a way that would actually send a signal that tax-exempt hospitals are required to do more than just come up with a policy that they don't actually have to follow. All right, so there are lots of gaps in these federal protections. It's not that there hasn't been activity, but the big agencies, CFPB and the IRS, have really sort of like, I think, slow-walked their policy efforts and enforcement of on the medical debt policy. Partly that's because I think it's a political landscape, right? CFPB and IRS are also the two that have been the most attacked by Congress and through appropriations. In the courts, right, there's like, it seems like every other year there's a case against the CFPB challenging its like fundamental structure. And so it is those two agencies, though they have the statutory, the authority on paper, they've not really been able to do much with that authority in practice. So this means that a low-income patient who wrongfully loses their home or is forced into bankruptcy or is unable to buy food or pay rent, or is denied medical care because they carry debt, has no recourse, right? There is no protection against that person, even if the hospital that is suing them or pursuing them legally in court over their medical debt really ought to have offered them financial assistance, right? Even if there are legal requirements that they should never have been subjected to harsh collection practices. And there's really just no remedy for the harm suffered by that patient under the federal standards. So states have stepped in to fill that gap. So this is one sort of positive example of dynamic federalism where states have passed stronger consumer protections than the federal government, so it sort of builds on a federal floor, but fills in those standards and fills in for the weaknesses that we see in the federal, for example, IRS rules. They're more inclusive. For example, they apply to all hospitals, not just nonprofit tax-exempt ones, other types of providers. Their standards for financial assistance and income thresholds and medical expense thresholds are clearer, so it's not leaving less to hospital discretion. Stronger protections against debt collection actions, and potentially, and this is the most important one, the creation of, I think, a handful of cases, 3 states in particular, enforcement through private remedies in addition to administrative enforcement. So all the public law from both the federal and the state level has an administrative enforcement component, whether it's the CFPB or the IRS on the one hand, or the state attorney general or the Department of Health and Human Services at the state level. Of course, the problem with all of this is you have a right we've heard this theme today, right? You have a right given to you under public law, but without enforcement, that right is not worth a whole lot. And so one of the things that we've seen that's been the most effective gap filler, or at least most potentially effective, I don't know if we have data yet on whether it's actually being used, is for the state to create a private remedy, whether it's under the state consumer protection laws like unfair deceptive actor practices laws, or through the creation of an actual, private remedy, like a cause of action. So that's, I think, the main point, the takeaway I'm gonna leave here before we turn to discussion, is really it's the creation of these private remedies that I think is the most important contribution that the states are making. So it's both a private law contribution as well as a federalism contribution. And the reason it's important is because it makes up for the federal regulatory failure that we're seeing. Sort of complete lack of enforcement, complete sort of, even though again you have paper authority, there's just a lack of undertaking that rulemaking authority, a lack of enforcement, and really a fear, I think, that these agencies are disinvested in. IRS in particular has been, gutted. CFPB has been also threatened to be gutted. And so there's a lot of regulatory failure at the federal level that I think that the states and private law fill in the gap. So it's a both and approach. Again, it's not one is superior to the other. We need both, but in the scheme of a world where there's no enforcement, we can't rely on public law alone to solve the problem of medical debt. So I'll leave it at that.
Well, thank you. Wendy?
I'm really glad that you're taking this on, as you know, because you and I have had this discussion. I mean, I agree that this is a tremendous problem, and I'm completely there with you on the fact that many of the mechanisms that currently exist are underpowered or underenforced or deficient in some sort of way. But I want to push you a little bit on how helpful the private rights of action are. I'm wondering who you think is going to sue, particularly in a world where you can essentially contract out of class actions these days. Like, who's going to take on these cases? Are consumers going to be, in addition to being able to find counsel, are they even going to know that they have a right of action? So how will this work in practice?
Yeah, I think that there's a problem about sort of getting people's rights out to them, and I think that is an issue. There are consumer advocacy organizations at the national level and at the state and local levels, and so they've sort of had to shoulder a lot of this. But I think that with the private right of action, especially if it comes with an unfair deceptive act or practice claim, which is exists in every state, it comes with attorneys' fees, costs, and oftentimes statutory or punitive damages. And you just put a complaint on my desk there that just said, like, there are attorneys that are willing to take these cases, particularly when they come with attorney's fees and costs. And you're right, it's not 100%, it's not every patient is going to be able to avail themselves of this. But you can get representation if you can win attorney's fees in court. And I've talked to legal aid attorneys who are like, we will take these cases if we can get attorney's fees. We are motivated to take these cases. So it's really important to have the private remedy in there, again, with the attorney's fees, with the statutory damages, in order to motivate representation. And it may not be enough, there may not be enough legal aid attorneys out there or consumer attorneys who are out there, but I think that it's possible, yeah.
Thomas?
So I apologize because I'm kind of asking the same question, but wondering specifically about marginalized folks, and whether or not maybe there's also like a longer game to think about how we are pulling data or thinking about what a better system is. Because I think if you're a smart PE or hospital player, you know exactly who you can push against the wall.
Right, and there's even data about collection actions disproportionately burdening Black communities because they have less wealth to draw on, there's less community resource, and that they just, like any of us, you get a collection notice in the mail and a summons, you're gonna shove that in a drawer and you're gonna try to forget about it, and then there's a default judgment entered against you. So I absolutely agree that there is not sort of a necessarily an equity lever just with putting a private remedy in there. There's another piece I didn't talk about, and it's a data collection lever that some of these states have also done, which is to start collecting data at the provider level by race, by gender, by zip code, and by language spoken. And so that will also, in terms of how much data are you collecting, what is the income of these people? Like it's a first step. It's transparency. It's not all the way, but it does at least allow tracking of whether or not a particular provider is disproportionately burdening particular populations.
Lauren?
I just want to quickly highlight the irony of touting the benefits of dynamic federalism, particularly in this area. And the reason for that is, of course, that you get the state level innovation, right? Even though you have this lack of uniformity, that's also what led to the problem with Medicaid, right? In terms of both, up or down, accepting or rejecting the expansion, but also the waivers, right? So is there, just in terms of your views, is there a harm to talking about this in such a positive way because there's innovation at the expense of federal regulation that would produce uniformity and protection?
I'm ambivalent about federalism. Like, I keep trying to figure out if federalism is net positive or net negative for equity. And it depends it's a double-edged sword, right? Like, exactly as you're saying, it's the same states that are opting out of the Medicaid expansion because they were given permission to do so by the Supreme Court that have the most sort of inequitable impacts of these policies. And it's not those states that are necessarily passing these protective laws, although some, even Republican-led red states, have some protections. They don't go as far as some of the ones that I characterize in the paper. But you're right. So it's not an equitably distributed solution, which is why we still need the federal floor. And we need to strengthen the federal floor. We need to, hold CFPB and IRS's feet to the fire. So we still need that federal floor, we need it to be strengthened and clarified, but at the same time, what we don't want to do is say, well, this is only the federal government's job and there's nothing anyone else can do to step in. It's a both and. So I'm totally with you on the.
5.5 minutes for Liz, Barry, and then myself. Liz?
So this comes off of Lauren's point too. I'm wondering if you have seen or contemplated any movement on a different type of state litigation addition. So changing the burden and the balance in the collection actions. Is there any movement to create a defense to a collection action, to create an immunity for certain patients if they have other criteria? The way that states, particularly red non-Medicaid expanding states, have been very happy to do in their legislatures when it's medical malpractice plaintiffs and provider defendants. So that might be a potential opening, but I don't know if anybody's.
I haven't seen that action, that movement, but that's a great idea in the sense of like, how do you extend consumer protections into those states, so that people have tools, yeah. But thank you.
So, Aaron, I have a question about whether you found any cases in which the state taxing authority has gone after a nonprofit for its nonprofit status violation in aggressive medical debt collection. Pennsylvania's been aggressive in some
Right.
diminishing community standard. You meet
Right.
community needs, but I wonder if anybody's used this as a wedge to go after a hospital.
I haven't seen it go all the way, but I would imagine it could be one of multiple factors in the various states that have a stronger set of requirements for state tax exemption. Yeah, no, I think that's and Colorado has this like novel thing where it's not this, but it's, so states are trying to use this lever creatively. Again, query whether this could ever be enforced, but Colorado passed a law that said, if a hospital is not compliant with the federal hospital price transparency laws, it is disallowed from suing any patient ever. And so, for medical debt. And so, again, who's gonna enforce it? But I think you're right to think, let's think creatively of who the possible administrative enforcers are, who can potentially help with enforcement.
So my own thought is about the big picture sort of irony of medical debt, where we design a whole system that's designed to create medical debt, really, by leaving people uninsured and underinsured. And then once hospitals try to collect on the medical debt, by collect, I just mean use legal process. Like go to a court and say, you created this debt by policy, can I have my money? We call that predatory, or some authors have really tried to shame hospitals for just using their legal mechanism. There's other things that are clearly beyond the pale. But I wonder if we need a theory of what is medical debt abuse.
What's predatory?
Versus what's medical debt banal status quo that maybe we would all like to change the system so there isn't any. But if we're gonna have a system of medical debt, what should the ground rules be?
Well, I think that's where the states have done a better job of defining for whom would medical debt collection be predatory, and it's those income thresholds. It's, some states define it as someone who, earns under, say, 400 or 500% of the FPL, or spends in excess of, 10% of their household income on medical expenses. So anyway, I think
It's
that
strange to even create medical debt for that population.
Right.
And hang it around their neck, but then say, but hospital, don't try to collect it, they just need to walk around with this debt.
Right.
For no particular purpose.
And I think you're right to point out that there are legitimate medical debts that
Yeah.
we don't necessarily want to sweep into the whole predatory medical debt problem.
Chris,
Please, Tom.
I just have to say in defense of the CFPB, we meaning the consumer organizations, had a meeting with them about 8 or 10 years ago, and they were very engaged. The biggest problem with them is that they don't have jurisdiction over hospitals.
Right,
And,
as first-party collectors.
and they were very apologetic about it, actually. But I did make an argument to them about what constituted abusive medical debt, and that was suing for charges rather than, the market price.
Which is an interesting question. What is the market price? I've tried to litigate that question and lost in several different
And
ways.
most people can't afford even the market price, right? Like they can't afford their deductible, so.
So we have 60 seconds or 53. Going once, going twice. Great. Thank you so much, Aaron.
Thanks.
So our next speaker is James Toomey on how the common law can legitimately restrain balanced billing.
Great, thank you, Chris. Hi, everyone. It's great to be here. I've learned a lot already today and look forward to learning a great deal more. The paper I'm talking about today, or the chapter, is presently titled, has been retitled, but still provisional, Conceptual Private Law in Healthcare Finance. And my project in this paper is sort of trying to see this case study in healthcare finance through the lens of, or apply some of the foundational core debates that are going on in private law theory. They've been going on for over a century, but have sort of picked up in the last couple of decades. Those sort of foundational debates are about the status of the legal concepts and the conceptual language on which courts rely in our common law system when they work through legal questions. As we know, right, the language of the common law is famously or notoriously conceptual. We have practical outcomes turning on whether a court thinks some phrase counts as a promise or whatever it may be. And the way that the courts typically think about this, or at least present their reasoning, is through, reckoning with the conceptual boundaries of what it means to be a promise, what we're looking for in this area. And so historically, and this is still debated today, right, there are two sort of broad ways to think about what the law is doing when it applies this conceptual language, right? On the one hand, we might think that the conceptual reasoning of common law reasoning is some sort of facade or in some way supervenes on underlying policy reasoning. This is, of course, what the legal realists and law and economics school think of concepts. But the other view, and there are a range of views in this bucket, sort of take the conceptual language of common law seriously. They say that courts do something real and not obviously reducible when they engage in conceptual reasoning. Now, of course, right, a lot of the legal realist skepticism of the reality of conceptual reasoning in common law is grounded in a broader skepticism about the reality or sort of extra legal existence of concepts generally, grounded in some belief typically that such abstractions can't or don't exist. And so if you believe that, of course, the conceptual reasoning of common law courts must be a facade for something else. In this short chapter, I basically have to bracket that debate. There's a large philosophical debate on both sides about sort of the ontological and epistemic status of concepts, including legal concepts, and the value or possibility of the kind of reasoning that it looks like courts are engaging in. In this piece, I basically assume that maybe, it's possible, and this case study can sort of illustrate what that might look like in practice. And then I'm also trying to think through, well, if that's possible, what are some of maybe the benefits in practical terms in a case like healthcare finance? So what are some of those benefits? Just to summarize the arguments that have been made in the private law literature. On the one hand, if conceptual reasoning is really what courts are engaged in, that might be good from an epistemic perspective. Right, legal realism, law and economics schools famously rather sanguine about the ability of individual judges to sort of reach the correct utilitarian outcome in particular cases. But we might be skeptical that judges are actually the best people to do that, or they're any good at it. So what concepts can do, and hopefully this case study illustrates that, is they can sort of package rough, general, domain-agnostic rules in epistemically accessible and exportable ways that can apply in different places in the law. And so even if ultimately we're utilitarians, maybe packaging the law into these concepts has epistemic benefits across domains and allows judges to sort of quickly reach roughly right conclusions. Second, a conceptual theory of private law can help make sense of the arrangement of institutions we actually have as a matter of political theory. The legal realist view under which this is all sort of utilitarian reasoning in the background, in addition to thinking that judges can do that, has to sort of presume that judges should, but we might doubt that, right? Maybe we're not all utilitarians, maybe we want democratic majorities to be able to sort of adopt different moral frameworks or principles, and this sort of raises the question under this view what judges are doing and why they ought to be. And finally, and relatedly, I just want to point out that the private law theorists who argue that conceptual reasoning has a role to play here uniformly agree that the idea of the existence of a concept does not entail that it must be applied precisely in the ways it has been in the past, right? So these theories of private law are consistent with the idea that the common law can really adapt to and apply to new unanticipated factual circumstances where judges apply core concepts to new circumstances, but in so doing aren't necessarily doing something that is just policymaking. So that's sort of the normative theoretical background or framework of the lens through which I'm viewing this case study. What is that case study? I won't dwell too much here on the details because Jackson will inform us in more detail about sort of what this domain looks like. But from my perspective, the bottom line here is that in healthcare finance, we've got two situations, or at least arguably two situations, that in many ways look quite similar, in which courts are called on to estimate the reasonable value of medical services, and in other ways, these factual circumstances do look different, especially insofar as they come in different domains of the law, right? So we've got one coming from contract law, one coming from tort law. The contract law context is if we accept the argument that where a patient enters the hospital, they don't meaningfully agree on a price for the care they've received. We've got a background common law principle. The court is supposed to look to the reasonable price in such circumstances, impose that. And then in the tort context, we have where a patient is injured. The court needs to estimate the value of the medical care they've received. And it's a basic principle of tort law that the patient is entitled to recover the reasonable value of those circumstances, those expenses. So these circumstances in many ways, right, look quite similar in both cases. Because of how the healthcare finance system is set up, we have reason to believe that really neither the amount that the healthcare providers are billing or saying that they're billing, nor necessarily the amount that sort of the average amount insurers are paying or any given insurer is paying is likely to be meaningfully reasonable. So from that perspective, right, we need to, in both of these cases, to find the reasonable value of the services. It's not obvious we can adopt a clean principle to do so, looking at one heuristic or the other. At the same time, right, these are different legal questions. They arise in different legal domains. So something that has happened in the past couple decades on the tort side is you've got courts increasingly saying, it's still a handful of courts, but increasingly saying, well, this question of the reasonable value of healthcare services is just a jury question, and it's a jury question to be made on consideration of all relevant evidence, so that includes the amount that the provider is billing, that includes any amount that was paid by an insurer, including potentially what other insurers would pay for those same services, all relevant evidence. And how these courts got here really is an exercise in sort of reasoning about the basic concept of reasonableness in tort law, right? Reasonableness is a question of fact. It is supposed to incorporate sort of community standards, and to that extent is generally and presumptively a jury question, unless we are confident that we can adopt sort of a rough heuristic that will estimate reasonableness as a matter of law. And the courts are saying we just can't do that in this area. So if that's right, then it might make sense, or we might think that courts also should apply the same mechanism of discerning the reasonable value of medical services on the contract side as well, right? So in that context, you've got a provider suing a patient for non-payment for collection, and you could have the courts relying on this body of tort law, importing that sort of same way of thinking about the concept of reasonableness into contract law and say, look, the amount that the provider is entitled to recover is a reasonable amount on consideration of all this evidence. And so you might ask, well, why might courts be able to do this, right? Is it the case that it's just the sort of utilitarian correct answer in both cases? Maybe, right? That might easily be the case. But there seems to be an advantage here if courts really are doing something real when they define the boundaries of what it means to have a reasonable medical price. You do that in tort law. The same perhaps should just go for contract law without necessarily having to relitigate from the ground up whether the calculus works out the same in both domains. Right, and so what's interesting about this case from my perspective is that, right, if what I've said is plausible and analytically right, what is happening here is a bit hard to make sense of from the realist or law and economics perspective of legal concepts. We've got courts thinking about this basic concept of reasonableness in the tort law context, sort of thinking about what that means and reaching what seems like a conceptually coherent or defensible position, and then importing that directly without redoing that same kind of calculus into another area of law. If the realists and the utilitarians are right about legal concepts, then we would want to see that calculus done from the ground up in both cases, but perhaps actually just as a pragmatic matter, that's not what they should or need to do. So that is the basic structure of the argument in this piece. Obviously, I'm trying to pack a lot into 5,000 words, but I'll stop there and look forward to hearing what you all think.
Great. One of the things I love about health law is we get to go all the way from ontology and epistemology to like medical debt and everything in between. Mark?
I was going to say, it sounds like Chris's book. So, but anyway, so yeah, terrific paper, and I just so agree with the point that you're making. And I guess I just trying to think, what is it the courts, might say to defend themselves? That they regularly allow the jury to determine reasonable prices in one setting, but are super resistant in the other. And perhaps it is just the context that in the contract enforcement setting, the issue arises when you have essentially a failure of contract. There was not a price term, and there was not even an enforcement agreement because of the circumstances. And I think maybe what might make the courts hesitant is not that they're not willing to determine this, but they don't want to essentially say every single encounter with the hospital, has to get litigated, as opposed to a tort suit where something, bad happened and it was adjudicated and there was an injury, and you sort of have no choice but to adjudicate the issue, to sort of open the courthouse doors to having reasonableness determined whenever there's a non-specified price term in a health services agreement. I love those little tabs that you have to sign, financial responsibility. Okay.
You can give a document if you ask for it.
Yeah, anyway, that would be another empirical project. How often can you actually get the document? Anyway, but it just seems like way too much litigation. I don't know.
Yeah, so I take that point, and I think it's probably descriptively part of what's going on here. I mean, it is much easier. You've already got a tort suit. We have to determine the damages that's going to go to the jury. Part of that is medical expenses, but there are other damages the jury has to determine. So we may as well litigate this question here. Whereas I think you're right in the contract case. It looks like this is a much broader range of incidents that might be litigated. So I think descriptively that could well be what's going on. But it doesn't make a huge amount of sense, right? Because you do have the court saying, well, reasonableness in this context means X, and then we're just going to defer to what we, in another opinion, said is outrageous in this other context. So yeah, I mean, I think there are a couple descriptive reasons why you might see more willingness on the tort side, but it does sort of seem like that's a problem, and I think that is at least normatively and analytically supports the argument or is consistent with it, because we do need some descriptive explanation for why it is that this doctrine has arisen more in tort than in contract.
David Rosenberg.
Well, there is just one difference between contract and tort, and that is in contract you can always write in the term. So in a sense, contract is a different format. You are looking at rules that are probably default rules. And then the question is, what's the most effective default rule? I'm not going to suggest which one is most effective, but I think the point that was just made, where every contract claim becomes a tort litigation, would lead to a lot of distortion of the marketplace because of the costs of litigation. So that would be one thought.
Yeah, and I think that there is something interesting conceptually going on here between the boundaries between contract as understood as agreement and between tort understood as providing damages. There seems to be crossover specifically in this area because on the one hand, when you're estimating the reasonable value of some expense, in most areas you'd probably think of that as kind of a quasi-contract, like you're trying to approximate what the parties would have agreed to, at least reasonably. So you're imputing a kind of contractual arrangement or taking a broader view of like how those contracts would work out generally when you're estimating specifically the reasonable value of something that people could contract for. At the same time, yes, of course, right, like in the contract domain, you can agree on a price and that will be enforceable. We're dealing in this circumstance with something that is sort of quasi-contract, right? And from that perspective looks a little bit more like tort because the parties actually did, the premise arguably is that the parties actually did not agree on a price term, which is the only way we get to the sort of reasonable value in the first place. So I take your point. It's true that there are these boundaries between the idea of contract and the idea of tort, but I think this is specifically an area where you see that conceptually blurring.
In part because in practicality, it's infeasible to pre-specify the price or even pre-specify the services in particularity. So, I mean, Ian Ayers has talked about penalty default rules and maybe setting the price to zero. And Wendy's brought that into the health context in particular in her work. But that's premised on the possibility that the offerer could have specified a price but kind of declined to do so. And that's
right, contract isn't, like, it's just an odd conceptual fit in this area. The idea that you can sort of bargain and actually agree on a price beforehand isn't a great fit. So it seems in some ways what the law is doing is quasi-tort.
And that really begs the question for this conference as to whether we should keep even playing that game or just get serious that this is actually a place where you need ex-ante regulation and price setting or some other statutory defaults or something that would get a little more realistic if we're not really doing contract or tort, but pretending to do so.
That's totally right, and I think that part of what I'm trying to do in this chapter is, well, okay, what are sort of consistent with the basic ideas of common law theory? What could courts do in this area, and what can't they? And maybe what they can do is this sort of crossover between contract and tort. But that might be a little bit helpful at the edges, but certainly we're not talking about something that's a radical change in how we pay for healthcare. Surely it's not enough because most people wouldn't be able to pay the actual market price anyway. We may need to look to public law solutions if all we can do in this area is this kind of jury litigation.
And I'm wondering whether or not a third model that you could look at is the No Surprises Act, or the independent dispute resolution, which is sort of a contractual IDR, but within boundaries, right? Like there are these guardrails or benchmarks, which ended up not really being about the QPA, and like the whole idea that there is that the public law determines what the guardrails are for defining what the reasonable price is to give and what is out of bounds, right? Like not public payer rates, not charges, but something that is benchmarked to the median and network rate. And so that is something that goes a step further, acknowledging the problem that courts have had, and maybe, I don't know whether or not that comports with your theory of like this is really a quasi or a hybrid, and whether that approach is consistent with.
Yeah, I mean, I think as a matter of public law, that totally makes sense. I like, as a conceptual matter, courts can, and I think it makes total sense to say, we don't really know how to do the reasonable value here, right? What is that? It's gonna be a jury question. How should they do it on all relevant evidence? What they couldn't do, I think is sort of a conceptual matter, is say, okay, the reasonable value is X, or it's bounded by X and Y, or it's, some percentage of the market rate or whatever it is. Public law can do that, right? If you want sort of, and it's totally defensible, to say that, the reasonable value of these services is gonna be between X and Y, or it's going to be calculated in some particular way, that might be the right call, but that strikes me as a sort of core matter of public law and not something that really would make sense to accomplish through litigation.
Barry, we've got 30 seconds, last thought.
Can I apply fiduciary law? Claw back the excess between the charges to the insureds and those who aren't insured, because it's predatory pricing for those that have accumulated the debt. So there's an in-between doctrine for you.
Yeah, I mean, so the fiduciary angle I hadn't thought about too much. I mean, it runs into problems of like, what do we mean by fiduciary in this context and who is standing to sue, but that's something to certainly think about, yeah. Thank you.
Well, great, thank you. So bringing us insights from the trenches, Jackson Williams, Vice President Public Policy for Dialysis Patient Citizens. Right, talking about health law's sheathed sword. Why hasn't civil litigation dented healthcare costs?
Can you pass over the clicker, please? Well, thank you all of you who slogged through my very prolix manuscript. My interest was in whether private law can reduce unreasonable healthcare costs, which takes up a big part of the article, and then sort of the political science question of why did we get a public law rather than a private law solution to surprise medical bills? So my conclusion is that while there is substantive law that's favorable to litigating excessive healthcare costs, the mechanics of asserting it are largely unfavorable. In terms of substantive law, there is some good case law for litigating antitrust claims against providers, if not a lot of good case outcomes. The quantum merit doctrine is available to challenge bill charges of out-of-network providers, and some people, such as myself and Barack Richmond, have been more sanguine about the idea of there being a common law solution to surprise bills. It sounds like not everybody here is. Aetna was very successful in invoking tortious interference with provider network contracts in its litigation with out-of-network providers, and UDAP statutes are available to invoke, though I haven't found any relevant case precedent on this. But the mechanics are unfavorable for a lot of reasons. Number one is that lower prices for healthcare are a public good. And the most obvious to me parties to pursue lower prices are payers, such as insurers or TPAs or employers. But of course, they exist to protect their own bottom line interests, not to fix healthcare. And when I say they're the most obvious litigants, I mean basically the most practical litigants, because, for instance, quantum merit is not going to be asserted by millions of individual consumers defending collection lawsuits. So we've seen a lot of individual party litigation where a payer tries to resolve a dispute with a discrete provider. And these suits can achieve a collective good incidentally or as a spillover, like malpractice suits made anesthesiology safer. But in my opinion, what we would really like to see is collective action to secure this collective good of tackling high prices. And I don't think I need to go into the number one hurdle here, obviously, is the collective action problem. I think everybody is familiar with this theory that's out there. There's not only a disincentive for an individual payer to do something that will benefit others, including competitors, but there's also a further disincentive for groups of payers to form successfully if free riders can enjoy benefits. The number 2 here is payers' uncertain incentives to pursue cost containment at all. First, we have insurers that can pass along high prices and can actually keep more profits when prices are higher. Second, we have employers that are indifferent to whether they are paying wages or benefits and need to keep employees happy with broad networks. So the only really motivated payer is union health funds, since they bargain for total compensation and can transform reduced healthcare costs directly into higher wages. But they, of course, are the smallest category of payers, and the payer with the largest resources has the least incentive to do this. Now, there has been a lot of individual payer cases that my paper reviews, and there are some insights to be gleaned. Blue Cross of Wisconsin versus Marshfield Clinic was an insurer suing a health system for antitrust in the 1990s. This is the only case of its type, to the best of my knowledge, as it so radically departs from economic incentives to avoid such litigation. Aetna sued what it called outlier doctors, who were referring cases to assistant surgeons or enticing patients to use their own out-of-network ASCs by waiving coinsurance. And these lawsuits were successful. They shut down the drive-by doctoring technique, so there were spillover effects there. United Healthcare took on the private equity-owned physician staffing companies. And as we know, it was legislation rather than litigation that curbed the out-of-network business model. United was able to get traction on the quantum merit argument, not really in reported case law, because some of this was happening in terms of contracting negotiations and arbitrations. But they also proved to be an unsympathetic and divisive plaintiff. Historically, United has shortchanged doctors, and during a trial in Nevada, they were even caught shortchanging employers by keeping some of the difference between billed charges and their allowed amount. Litigation between these two sides continues, now centering around upcoding. It's possible that this and other litigation filed some of the sharpest edges off the hospital-based physicians' MO. We know that they made some concessions, such as ending collection suits for balanced bills, but it's hard to tease out the effect of litigation from, say, the effect of bad publicity. Centura Health versus French is known primarily as a case that successfully invoked quantum merit against a hospital, but the real significance of this case is its backstory. The case was orchestrated by a TPA that uses reference pricing rather than provider networks. For the reference pricing program to work, the TPA must be able to defeat bill charges and gain assent to a market price. This decision was a green light for the reference pricing model, so though it remains a very niche plan designed for just really smaller employers. But the decision definitely had some spillover effects. And finally, UEBT versus Sutter Health is the big success story, and we'll discuss why in a minute. But other than that, in this individual litigation, you see mostly singles and strikeouts rather than home runs. But the good news is political science theory posits 3 solutions to the collective action problem, and each of them applies to cost containment litigation. Government can coerce participation in collective action, exemplified by the Wagner Act for labor unions. The legal analog is class actions, where participation and fees are mandatory. There were 7 class actions on surprise medical bills, including 3 that were settled, though that is about 47 fewer than were needed. Government can provide public goods itself, and here it is attorneys general that are relevant, and the most interesting litigation that's pending right now are the UDAP challenges to insulin pricing that allege collusion between pharma and PBMs. And the third solution is wealthy patrons, which support most public interest groups. The relevant private law activity here is the Fairmark law firm's cases against providers, which you probably read about in the Wall Street Journal about a year ago. So these are cases that are being funded by philanthropies. 4 of them are antitrust cases. that are sort of lookalikes to Sutter Health, and the fifth is the one that Aaron mentioned. And so the idea of having a wealthy patron support litigation is what's happening in this attempt to curb New York or North Carolina health system's debt collection practices. And let me quickly mention a final hurdle. There is a bunch of political science literature on when litigation is likely to be used by interest groups. And most of this literature predicts that it would not be deployed by payers against providers. And you can see the various theories and findings up here. Community pharmacists versus PBMs is a more likely litigation dyad. So what can we expect to see in the future? I think an outline of what successful cost containment litigation would look like is visible in UEBT versus Sutter Health, union-led in the form of a class action with Attorney General support, kind of a trifecta. And now we have this patron-funded class actions that Fairmark is bringing. There are employers as lead plaintiffs. I think this is a promising formula too. And I think some of these cases will succeed. I guess the unknown is whether they can actually deter predatory behavior by monopoly health systems. And, that remains to be seen because obviously the Sutter Health settlement has not deterred any of that activity. And the other big question is whether employers will ever collaborate to challenge egregious provider practices. Arguably, price transparency by giving them the tools also gives them the duty to do so. One way employers might insulate themselves from ERISA liability would be contributing to a litigation resource center to investigate providers and bring suits in appropriate cases. That you can tell my bias on this. I hope something like that happens. Thank you.
Excellent, thank you. So we have almost 10 full minutes, and Wendy, please start us off.
Super interesting topic, really important. I couldn't help but think about the sort of recent trend in vertical consolidation amongst payers and providers. I'm sitting here listening to you talk about this though. Of course, they're pitching it as, a way to improve quality and reduce costs, and lots of folks are very skeptical of whether or not that's actually going to be the case. But I'm wondering, to what extent the consolidation kind of plays into the topic.
If you're talking about like a Kaiser Permanente or West Penn, Highmark thing, I don't that personally doesn't bother me. I think that as long as you have a lower priced alternative, in theory, the competition should bring down prices. But I know that folks are skeptical about that.
Mark?
I'm curious what the ERISA argument would be, a duty to shop for better prices?
Yeah, I mean, I'm not the person who's articulating this. This is being articulated by other people. And I think, I don't know if Christine's paper covers this at all, but the theory is that if you are the plan sponsor, you have a fiduciary duty to get the best prices from providers for your enrollees, and if you have in front of you now, you can go and get all of this information on what prices are available out there. If you find out that you are paying more than everybody else, then there might be some liability there.
James, and then Christine. Oh, actually, Christine, if you want to follow up on that, then we'll hit James.
Sure, yeah, and I think, and I feel like it might be worth it kind of expanding this into your paper too, just a little more since you do get to it at the end, and I think it's exploring where it's plan members or plan sponsors really bringing the cases against their TPAs to be containing costs better, and I think the long term maybe helpful but difficult to realize would be to have them negotiate better rates, but I think kind of in the shorter term, some of it is actually just cost containment on the TPA's actions themselves and getting rid of some of waste and fraud actions. And so some of that might be, there's a case against Aetna for imputing these kind of dummy codes into their claims, and so they're casting an administrative fee as a provider claim. And so trying to get rid of some of that, but then also you see these plans in unions in Connecticut that have sued Elevance. And really they're kind of saying you're not getting us the data that we need so that we can be responsible fiduciaries here and trying to control our costs. And we suspect that you, our TPA, is not actually negotiating, or you're not even paying out the rates that you have negotiated, you're paying more than that. So I think just kind of like thinking about too is not just having providers as the defendants here, but the plans, the insurers as defendants, and kind of other entities of plan sponsors, plan members as plaintiffs, but also recognizing there are a lot of limitations there and kind of just, is there actually damages, and exploring kind of just the bounds of that where it's possible but maybe limited too.
Yeah, so I was wondering if you could, if you have any thoughts on whether there are good examples in which sort of private law or quasi-private law litigation led to cost containment in other industries. And you might say healthcare is unique, and that's totally fine. But I guess what I'm getting at is the problem here really that litigation is just a bad tool to contain costs in any field, or is it that the way the healthcare system is structured, it's less likely to be effective here than in other areas?
I mean, to me, it's a question of, is litigation going to move the needle more than waiting for legislation to pass? And I, as a lobbyist who's done this stuff for a long time, I know that it's extremely hard to get any kind of legislation passed, but getting something that takes money out of providers' pockets is especially hard to pass. So I think that there needs to be this alternative parallel track if you want to put pressure on prices.
Well, one interesting thing about the insurance world is I'm told that the insurers have essentially adopted a price plus model where they actually have an interest in underlying prices growing, and then they charge essentially an implicit or explicit fees on top of whatever the prices are. So they don't have an incentive to drive prices down.
And the medical loss ratio makes that worse.
Yeah, but why haven't we seen, one of the maddening things about health law is self-insured plans, where employers, at least in theory, take the skin in the game themselves. And that has big preemption consequences and makes a lot of other health law much more complicated. But the advantage of that should be that at least employers can use a private law, old-fashioned contracting, to drive down prices. But that doesn't seem to help either, does it?
I think that if employers and employees had the same kind of relationship with the savings that union members have, personally, I would like to see a system where there are maybe purchasing cooperatives that employers join and lay out a baseline price of or baseline projection of what they think they would be paying next year under the business as usual, and then an alternative projection of what they would be paying if they, say, eliminated New York Presbyterian from their network, which is how the building and janitorial union did it in New York, and say to their enrollees, look, we're going to make this deal for you. If you are using this provider, you're at risk of not getting to use them next year, but we are going to promise you this dividend if you, I'm not suggesting that it'd be put up for a vote, but I think it would give employees more of a stake in these negotiations, which you don't want, obviously, to result in an impasse.
Lauren and Thomas?
So it's interesting. For a brief period, I, in practice, helped represent management trustees for large Taft-Hartley funds. And thinking about how the ERISA fiduciary duties might lend itself to a duty now that there's increased price transparency to go after, to file litigation, I wonder what you think about how that contrasts with the duty to contain administrative expenses for the fund. So, I heard a ton of discussion in practice about how our administrative expenses were getting too high, but if you throw litigation in there as a fiduciary obligation, I think it's going to come up against the fact that these litigations, even for some of these Taft-Hartley funds that have huge amounts of assets under management, costs related to their welfare funds, it'll just get too expensive to be an effective tool.
Yeah, I mean, really,
Can I just jump in really quick, because I think they fit together? First of all, I'm a neophyte, litigation isn't my space, and I chose that very specifically. But I wonder too what the threat of litigation does, and whether you actually have to get to court to get them to play ball.
yeah, UEBT did that class action against Sutter Health on a contingency fee basis with a plaintiff's lawyer, so that made that easy choice for them. But, I'm thinking of something like a checkoff where employers would contribute, 50 cents per enrollee to have some sort of litigation resource center out there, and the very existence of it would hopefully deter some of the worst excesses.
Maybe we could even put that at a law school and staff it with students, so we can train a whole generation of lawyers
There you go.
suing.
I have a question if nobody.
Oh, go ahead, Erin.
Well, and I think the question goes to this idea of the sort of the ERISA fiduciary duty, but also on cost containment is you point out that there's nobody, not the employer, certainly not the TPA, not the broker, has any financial incentive to actually press down on costs. Not a strong one, right? Because they're not actually, they're kind of indifferent. And so one thing that I've been hearing from I guess it's the Purchaser Business Group on Health and like some of the other actors in this space, is whether or not you can cut out the middleman. Increasingly, if TPAs are providing almost no value, they're spread pricing increasingly, right? They're adopting a page out of the PBM book, which is basically they're doing this sort of like price plus, and they're spread pricing and they're heightened costs, which they can't do as much anymore after the new fiduciary transparency requirements. Is there a way, like direct contracting, is that sort of, it's not litigation, but it's contract, it's still private law, to put some pressure on prices that doesn't necessarily require resort, or maybe you hold litigation in your back pocket. Anyway, I'm just wondering if there's like other strategies that are not legislative.
Certainly, I mean, I guess I would like to see a three-pronged approach with threat of litigation, legislation, and contracting.
Well, that actually puts us exactly at time. And thank you all. The conversations can continue. We'll do an applause and then